Okay, in this presentation, I'm going to be going over details that will apply to your paper after you get your first draft done and you've compiled your data. So remember, you needed to have a clear inquiry question, and then you have to have a good thesis that narrows in on one of the causes of the problem or a proposed solution that you think is narrow enough that can be implemented by actual human beings. And then you needed to find some data on that where people are talking about it, thinking about it, and then you're going to analyze the language, the symbols, and the ideology. So after you put that table together, you're going to work on the legal analysis of this, and this presentation is what provides that information. So I want to start with a real big picture. And I think the goal of this first part is just to kind of overwhelm you a bit, just so that you see how legal thinking is different than other classes. Even if they were criminal justice classes, if they weren't taught by lawyers or folks who have had experience in this world of law, you probably didn't necessarily learn the processes of law. And that's what this last part is going to be talking about. To kind of lower our expectations a bit, I don't need you to master all of these things. In fact, most first-year law students haven't mastered these things. I just need you to be aware of them and to start practicing, to start moving your brain to thinking about law in this way, as opposed to kind of law as a obey or a commandment. So I think I'm going to read it out loud just so you can kind of think about these things. So behaving like a lawyer or judge means processing information as a disciplinary expert, identifying legal issues and locating relevant authority, using inductive reasoning to evaluate relevant authorities, reconciling and synthesizing prior cases, engaging in rule-based and analogical reasoning at the same time, identifying relevant policy considerations, recognizing the malleability or the flexibility of legal principles, identifying and evaluating competing arguments and weighing their relative strength, predicting probable results and making recommendations from among alternative courses of action, adopting a client-centered approach to legal reasoning, applying critical reasoning and judgment to evaluate an issue, critically evaluating the reasoning and rationale for prior determinations. So these are not necessarily in order. These are all the things that lawyers do in their practice, and the same thing judges or lawyers. So I wanted to show you there's a difference here between the substance or the content knowledge. So context of law is what we mean by content knowledge. So it's not about memorizing laws. No lawyers memorize laws. What we're memorizing is the context of the law, and that's what allows us to do the process knowledge above. So that's understanding the context of law as different from other disciplines, but that includes some knowledge from other disciplines like biology, which is relevant to the study of crime, history, that is relevant to the study of slavery and racism, sociology, the behaviors of lawyers, police, and pedestrians, like stop and frisk, philosophy, about the interpretations of law, what the Greeks called the nomos, demos, and theos, and then more. There's music. You can apply law to music for copyright, advertising, trademark, sciences for patents. In economics, you can use for organizations, corporations, politicians, and that's just a short list. So in criminal justice, assuming that it's a study of crime, then biology would be the relevant thing to study with law along with sociology. For this class, what I'm trying to get you to see and what lawyers kind of have an advantage when they're working on any kind of a legal issue is that they have an awareness of rights that folks who aren't lawyers, who aren't judges, tend to not have as well defined, and they see it rather simply. And something maybe before this class you did, right? So you have to see the awareness of rights within a contest or a struggle for power. So you have to think about who gets to make the rules, who follows those rules, who enforces those rules, and then who gets away with not following the rules. And this style of reasoning that we're going to be doing is called abduction, or legal research is what most folks call it, but it's principally something called abduction or abductive thinking, which is different than inductive thinking or deductive thinking. So you'll see back in that definition, you do inductive thinking, and inductive thinking is like from the ground up, more of like a metaphysics kind of approach. Deductive reasoning is what you do in a lot of your classes, where you're given a definition, you memorize that definition, then you apply it to something. So you use inductive reasoning, you use deductive reasoning, but when it comes to final legal reasoning, you use something called abduction, which is a form of analogy. So the next article you're going to read, I think, is an interesting article, but it's an important article. And it's called Basketball and the Key of Law. And in a separate presentation, I showed you how to find this on JSTOR. I also have a hyperlink to it on the website. But what you're seeing here, and this is the quote that I think is really important for you to really, capture and understand, is that law potentiates, so it creates the potential of a world of rich and meaningful interactions, but it does not constitute that normative world on its own. In other words, law is not a thing. Law is not an object. It does not come in and create something for us. Rather, it requires the application of human will. So individuals organize their behavior to construct the bridge between what is and what could be. And this is what we mean by the concept of nomos, and using law as a form of nomos. And nomos, in the Greek concept of that, is a world of law that entails the application of human will to an extent, an existing, a current state of affairs, as well as toward our vision of alternative futures. A nomos is a present world constituted by a system of tension between reality and vision, or what I say to you often is the difference between law as real and law as ideal. And so we want to start thinking about the concept of law as a bridge. How do people bridge their realities, what they believe exists as a reality in their world, and how do they bridge that with other people, both of what they want as an ideal, wouldn't it be nice if we all got along, and then the reality, but what if we don't agree on the definition of getting along? And so we want to look at everyday life, or what's called folk law, to have a better understanding of how do people do this in their regular lives. And so this article is looking at street ball, pickup ball, and you see people invoking and using legal concepts to navigate through the game. And you can see this everywhere. Of course, I always listen for this, but you can hear it everywhere, at restaurants, in movies, everywhere people are evoking concepts of like, you're violating my rights, or that's not fair, you're not following the rules, I don't think I should have to do this, you don't have the right to do this. I mean, people say this a lot. So you have to understand law is constructed differently by different groups. And that's why there's no such thing as a universal law. Law is not a morals. Law is not norms. It's like norms for who, right? It could be norms. It could be norms for one group, but it doesn't apply universally to everyone. We also have to think about law as a wall. And this is a good, follow-up to what I just said. So in Scott versus Sanford, they held that a human being had no rights, that they had no protection under the law. And so if you see in here, the reason they explain this is not actually about Sanford. And this is something in my constitutional law class students struggle with. They seem to explain away the idea that the legal reasoning is because Dred Scott was a slave, or he wasn't a slave, he was freed, but that he had one time been a slave, or even that his family had at one time been a slave, that meant that he didn't have any rights. I think that's a good sociological analysis, or a deductive analysis of social relations. But that's not how the court held their position, and that's not how lawyers think about this. What they said here was that, look, the norm, the moral that was created in the Constitution was that white folks were superior to other people. That was the moral. And so these powers were explicitly granted to the government, whereas there were certain things they could not do. And one of the things they could not do was make someone who had, at the time was called or determined to be a slave a citizen. That's not something they could do. And one of the things that a citizen can do is they can sue in court as a plaintiff. And so the reason why Scott is not able to bring a successful claim in court and get his rights recognized is not because he's a slave, but because he doesn't have standing. He doesn't have jurisdiction. The court does not recognize him. Now, is that because he's a slave? Well, look, they didn't even deal with that issue. So, there's good arguments that could say he wasn't a slave. He had been freed. He had been in a free state. So there was no real sense that he was a slave. You could also get into more philosophical or sociological arguments and say, there's not really any such thing as a slave, right? There's somebody is told they're a slave. They're labeled a slave. They're physically restrained. But you weren't born a slave. The person wasn't born powerless. This is a process that happened through social relations. One group was taking power away from another group. And so, the court uses a level of legal reasoning that is very different than sociological or philosophical or even reasoning you do in your English classes. So law can be used as a wall, and we want to think about how do you build a bridge over a wall using legal reasoning, or how do you use the law against the law? So this is called abduction. And Justice Scalia, referred to precedent this way. So when an identical question of interpretation has previously been resolved by the same court or a superior court, the doctrine of stare decisis renders our advice irrelevant except to the extent that it may induce a court to overrule its own precedent or to narrow the case's application. This is what we meant in that first slide about law being very flexible or malleable. The law is not eternal. The law is not permanent. The law is not just an obey. It can change at any moment based on the arguments that are put forward. So you'll see a philosopher of technology from France here, Bruno Latour, writes, what makes law so hard to grasp, I think for non-lawyers, is that as soon as it has been defined as a separate world, right? As soon as you've defined it as law equals society agreed upon norms, it's been carefully delimited by its own tautologies or way of explaining itself, right? So you can take a whole class of telling you this is what it is. Then suddenly we notice how flexible it is, and with what confounding agility it absorbs all sorts of injunctions from other religions, politics, the economy, trends, fashions, prejudices, media. In other words, as soon as you describe law as a society agreed upon norms, I can say, okay, fine, let's think about politics for a second. Well, who got to place those norms in action, and where? Right? Because the norms of Seattle are not the same as the norms of Queens, are not the same as the norms of Virginia. And so the laws are very different in each of those places. And then within each of those locales, who gets to actually make the laws? Are they rich people? Are they poor people? Are they religious people? You see the difference here. This is a difficult kind of analysis once we start analyzing the law from different points of view. So an anthropologist and biologist, Gregory Bateson, talked about this as the social construction of reality, right? Our reality is constructed based on what social groups we're in. So abduction is the form of reasoning which a recognizable similarity between A and B, me and you, African Americans and Latinos, right? Whatever A and B are, but we propose the possibility of further similarity, often contrasted by more familiar types of reasoning like deduction and induction. In other words, we say, like in this case, we say, like in the Scott versus Sanford case. So, for example, African Americans are being targeted by police officers in particular jurisdictions within the country, like they were being targeted in Scott versus Sanford. Another case that I've asked you to look at is Chevron versus Natural Resources Defense Council. The Supreme Court has deferred to police in Terry versus Ohio, just like they deferred to the Environmental Protection Agency in the Chevron case. And this is known as judicial deference. And so you see, this is what seems to connect these cases together, even though they really don't have anything in common. It's different people, different time periods, different locations. But this is how law works. This is how abduction works. It makes an analogy from one case, compares it to the other, and links them together. Now, again, law is not doing this. We are doing this. Human beings are doing this. Lawyers are doing this. So one of my professors and mentors, Michael McCann, in his latest book, has a section called Law as a Tool for Social Change or the Status Quo. So law is a contested terrain. So the activists who are trying to change the law to enforce their rights and to overcome injustice see the law as a set of rules that exists as a result of a tug of war, which is a constant between the class that rules and those democratic forces that are ruled. At any given time, a law, in our view, reflects the relative strengths and weaknesses of its opponents and proponents. In other words, it's this kind of tug of war. Like they said, it's going back and forth. One side is trying to enforce the law, the other one's trying to resist it, the other one's trying to reconstruct it, right? So it's never something that is ever settled. It's never static. It's never sitting there at one time. Again, it's not an object I can go to the store and grab. It's a concept that people are arguing about and contesting. So we want to think about this in two terms then, precedent cases and landmark cases. So precedent cases are like Scott versus Sanford and Chevron case. They stand for the precedent, the rule of standing in jurisdiction. So one thing we have to think about in our paper is if the court has held previously that if you're not a citizen of the United States, you're not entitled to sue in a court to fix an injustice, when you start proposing your solutions, we have to make an argument to the court saying that this is the appropriate place to do this and why these people should be guaranteed their day in court. So you have to use the law and the legal principles to argue against this precedent. The second one is the Chevron defense, or deference. So you have to think about, which agency is going to be the agency that's most likely to be able to carry out the solution that you're proposing. And I'll get to that a little bit later in the presentation. Landmark cases, on the other hand, stand for large principles, things that you can see as like exercising your rights or rights awareness. So Brown versus Board of Education is for equality in education, and then Roe versus Wade is for the privacy of women. So I want you to start thinking, as soon as you've compiled your data and you're starting to analyze in these three terms. So these are the three I's of law. And these quotes come from a book called Distorting the Law by, again, my mentor and professor, Michael McCann. So you've got the instrumental, the institutional, and the ideological. So the instrumental is that there are dimensions of action that emphasize the tactical or strategic aspects of social practice. So this is like, what tools am I going to use when I'm trying to right an injustice? Am I going to start a lawsuit? Am I going to send a strongly worded letter? Am I going to protest? Am I going to urge my congressman to write a law? Am I going to use law in the more philosophical sense? This is what we mean by instrumental. In what ways am I using the concept of law to advocate for my position? Then the institutions, I think it's easiest to think about institutions as a place, right? Are we talking about court? Are we talking about Congress? Are we talking about City Hall? Or are we talking about the basketball court? Are we talking about the laundromat? Are we talking about the workplace, right? But each of those places has their own rules. They have their own norms. They have their own morals. They have their own set of circumstances and behaviors and habits and routines. And these encourage, invite, and reward various modes of interaction. So some people, if they quote unquote follow the rules at work, do better than others, while discouraging, disadvantaging, stifling, or excluding others. So you still see that exclusion of people based on all sorts of trivial things, right? Like color of your skin, gender, age, right? And so these processes are usually, like a workplace is usually designed by people with seniority. Those tend to be men. And so if you're a young woman of color, it's going to be harder for you to follow those rules, right? Because they're not built for you. They're not designed for you. And so we want to see within institutions, who do the rules favor? And then finally, we want to think about the ideology. And this refers to the things inside, right? Like as we kind of think about our relationship to others and we think about, how we fit into this structure of social relations, we want to think about how this kind of like aids our thinking, right? Like what are the structures? What are the relationships? What are the experiences? What are our material conditions as far as our economics, our education level, where we live, who we live with? We want to think about how that forms and reforms our opinions about the world. So when we think about this, it's like this, right? So this is how law looks. That's the ideology, institution, instrumentality. So for example, how you think, your ideology is built on your mental models, right? So you oftentimes refer to the court as a venue, a place that you're going to go to sue or defend yourself. And then the instrumentality would be legal research or abduction, right? The ability to take previous cases and defend yourself using those cases, or sue somebody, using previous cases. That's the tool you would use with that mental model. How we think on a more collective level is about rights awareness, things that we think that we have, that we're entitled to. And the institution here is now the institution of the limit of power, which is called the common law. And this is a way of standing up. This is the Magna Carta. This is the Bill of Rights. And so the instrumentalities is this use of precedent and landmark cases to argue our points. Our choices, on the other hand, are much more constrained. They're limited. And that's based on what we know, right? Our mental model of the substance of the law, and then also of kind of how we think about the institutions of Western liberalism, right? So if you're an immigrant, it could be difficult to have substantive knowledge about the law, and your mental model might be slightly askewed. You might be using a mental model from a different economic, a different legal system, a different social system that might not apply to these three principles of autonomy, welfare, and participation. So oftentimes students say, when they say law is a command or an obey, that's not consistent with the institution of Western liberalism. Western liberalism has been a limit to the abuse of power. This is the Magna Carta. This is the Declaration of Independence. This is the Civil Rights Movement. This is the 14th Amendment. These are all these freedoms that Americans talk about. And these are based on the right to participate and not just to vote, but also to form what are the rules, like what are the things we're going to follow. And so this is where I think that kind of difficulty kind of arises and is not understanding the history of the institution. At the same time, you have choices you have to make, and those are constrained, right? To sue or to not sue oftentimes depends on how much money you have. To protest or not protest depends on whether you can afford to get locked up, right? If you can afford to get arrested, or will you lose your job because of that? The choice to try to pressure a legislator or a congressperson or a politician to write legislation in your favor oftentimes goes hand in hand with money or influence, or how many people are you able to organize with. And then to construct the rules, right, to construct the substance, the knowledge of law, obviously depends on your education and your experience and your confidence and all these different kind of factors. And then finally, how to activate all of this. Your mental model isn't going to be activated unless you have the knowledge of the processes of law. How do you actually do this work? How do you do legal research? How do you analyze cases? How do you actually use this language? And then in the institutions, you have to think about it this way. I can't activate unless I have this concept of nothing can be arbitrary or capricious against me. And on the other hand, I have to have good hands, or I have to have clean hands. Meaning that I'm not doing anything arbitrary or capricious against somebody else. So some people have said, we should treat others the way they treat us, or we should treat everyone equally. Well, you can't really do that until you're activating the law. When you're activating the law, it's because you have the knowledge of these institutions, and you have the knowledge of the substance, and you have the knowledge of your rights, and you have the knowledge of the processes of law. Then you can treat people equally. Assuming then that you recognize the instrumentalities of resistance and or conditional compliance, meaning you're less likely to dominate someone or oppress someone when you're holding yourself to your own limit of power, right? And then you can recognize when people are abusing their power based on the shared construction of law. Now, this is all very ideal, right? But this is the three kind of levels of law that we want to think about. So process and substance together is best kind of explained when you look at the Chevron versus NRDC case. So the courts will examine the statutory language, that's the language of the bill, the thing that's been passed, the legislative history, which is the arguments that the politicians make with each other, the policy, and that's to make a ruling on a claim of injustice and whether governmental action is warranted. And in Brown versus Board of Education, you kind of see this the most clearly. But you'll see here what the court says in this case is judges are not experts in the field, right? They're not experts in the field of sociology. They're not experts in the field of taxes, for example, and are not part of either political branch of the government. Courts must, in some cases, reconcile competing political interests, but not on the basis of the judge's personal policy preferences. In contrast, an agency to which Congress has delegated policymaking responsibilities may, within the limits of that delegation, properly rely upon the incumbent administration's views of wise policy to inform its judgments. While agencies are not directly accountable to the people, the chief executive is, and it is entirely appropriate for this political branch of the government to make such policy choices, resolving the competing interests which Congress itself either inadvertently did not resolve or intentionally left to be resolved by the agency charged with the administration of the statute in light of everyday realities. In other words, the court is not to get into the battle between Congress and the president. And president gives his powers, right? He spreads them all around. And you're seeing that in the corona pandemic, right? It's not Donald Trump is not doing any of these things, right? Donald Trump gives the power to doctors, to the military, to his son-in-law, right, Jared Kushner, to Mike Pence, right? He delegates all this authority to all these people, and those people are not politically represented, right? We don't vote for those people. So we have to give them some deference on how they're going to enforce his commands, right? His decisions, because he's going to be held responsible. He's going to be held accountable, and people either vote for him or vote against him based on how they think these people who work for him did. Now, he likes to blame a lot of them, and we'll see if that works, right? Do people like somebody who blames everybody else and doesn't take responsibility? We'll see, right? Democracy gets to choose. So, but this is not the place for the courts to get involved, because Congress is the branch that can override the president. They can legislate him out. Now, the difficulty here is you'll think about the ideology of the institution, right? Right now, it is dominated by the Republican Party. So Congress is not able to overwhelm the president's choices. And so in some ways, the courts are trying to balance this out, and you'll see that in several cases. But in most situations, the court will kind of defer to whatever agency is working on the issue. And this could be Department of Education, Department of the Treasury. It depends on which issue you're studying. So what you want to do is you want to start with the language from your data. Look and see like what were people talking about. And then think about what are the principles and the symbols that they're referring to. And then move to which agency, organization, or actual human being is the best to implement the solution. And this is the argument you're going to make to the court in this paper. You're telling the court that what you need is for this agency to actually implement the solution in order for change to happen. So if you're thinking about homelessness and poverty, death row and education, migration and job security, climate action, pollution, these are some of the issues that you all brought up. In kind of order, health and human services would deal with homelessness. Housing policies would have an effect on poverty, right? One big issue that I learned about in the documentary I watched is that wages, right, how much money we make over the last 50 years have mainly stayed the same. They haven't gone up. But housing prices have gone, incredibly high. And so that doesn't take, a mathematician to be able to figure out if we're not making enough money to buy these houses, then more people are going to be homeless or housing insecure. Same thing with rent. I mean, rent is insane. And so if we don't make more money, then we're not going to be able to pay these rents. Or we have to choose, very different ways of living. Or we have to make sacrifices to our health and other kind of costs. If we look at death row and education, then you'll see like the justice system obviously deals with death row or with mass incarceration. But what people don't tend to look at is the relationship that most folks who are in prisons, and especially who are on death row, have not graduated from high school. So there's a relationship there. So the idea would be if we put more effort into educating folks, then they'd be less likely to be on death row and mass incarceration. And then if we look at migration and job security, well, that's the global trade and the World Bank. And so they could deal with the migration issue, and then the presidents and the national economic leaders of each country would have to come over and solve the problem of job security. Climate action and pollution, we'd be looking at the Environmental Protection Agency and the Department of Justice to actually enforce the law. So you see there's actual specific human beings in specific organizations that can implement the solution that you're researching. Now we want to think about the mass production of legal knowledges. And so I had us look at the popular media. And so that first article was CSI Science's Wishful Thinking. So it was looking at television. What does television tell us about law, about rights, and about social change? And so you'll see, in that article, it was all about, well, the TV. And this is true of most TV shows, right? They're telling us like nothing based in reality. I mean, they're not even really intended to be reality, right? They're escape from reality. So you want to think about your research and what does it present, right? What is the research that you're doing? What is the data that you're collecting? What is it saying, right? What are the people trying to portray through whatever it is you're looking at? And then you want to compare that to ideals versus reality, right? Is this based on wishful thinking, or is this based on the lived experiences of actual human beings? And then we put that into the framework of symbols, language, and mental models, or ideology is another word for mental models. Now we want to think about the lived experience of folk. This is the new article I'm giving you, Basketball and the Key of Law. So you want to think about, like, what do the people say, right? So you have, like, what is the big message of the data you're looking at? But then what are actual human beings saying? And are they saying the same thing? Are they saying things that are different? Is it because of their situation? Are they looking at the situation differently? And then apply your own experience, right? Connect to the topic. Say, this is what I think about this thing. And then you want to use your actor network maps that you practice with, right? You want to do the same thing here. So each of these people that you're examining, right? A homeless person is connected to a bunch of different people in their area. And then how connected are they to the politicians, right? So you want to see what's the most likely group of people who are actually going to make this change. So oftentimes the reason why change doesn't occur is that the people are too far away, right? They're either too far away, of their language isn't on the same page, their solutions are too far away, or they're physically, literally, geographically too far away. So then cases and judicial decisions, we want to get beyond the small claims court. So small claims is like, you hit me with your car, I'm going to sue you to recover my damages. You didn't pay me this amount of money, I'm going to sue you to recover my damages. So we want to think bigger than that. We want to think the cases like Scott versus Sanford, how do I get standing? How do I prove that this is the right court to sue in? And then which agency is the right agency that you want the court to focus on to actually implement your solution? So this is going to go back to that table that you did, the institutions, ideologies, and instruments. You're going to pick within there which one you think is the most likely to convince the court that it's relevant and that it can get presented as evidence. And then finally, we want to think about the big picture again. Customs, mores, and habits. And remember that these are local, right? So each group kind of has their own customs, mores, and habits. This is going to go to how likely is your solution going to actually change people's minds, right? Are people going to accept your solution? And so you want to think about the UN Sustainable Development Goals again. Go back to that early research you did and see, does this actually fix the problem that they identified? You want to think about human rights law. Is this helping people's dignity, their right to basic health care, their right to family, their right to life and liberty, right? You want to think about, what are these kind of big principles that we can apply? And then you want to remember, how do you activate this, right? So you go back to the consciousness. We have to be aware, we have to know the substance, and we have to know the processes. So how are you going to implement this in the sense that people are going to know how to activate their rights? And so you want to make sure you're measuring the difference between what is ideal and what is reality. So that's why when people say, well, law can't change. Well, no, right? Because we have this ideal, and so now we want to see how can we get there. Saying it can't change is just lazy, right? You're just saying I don't want to do the work to actually think about how it can change. And then the framework we're looking at are going to depend on your research variables. And that's what we've really been working on lately as I'm kind of going back and forth with you to just narrow down, right? So you can't look at the whole world. You have to look at certain places and you have to compare those. And that's what's going to tell us how we're going to be able to kind of analyze the information. So in your final paper, you just want to remember, right? This is like everything you're doing. The inquiry question, right? Be specific about the people and the location. Your thesis, right? Be very clear. How can the courts be used as a symbol, right? As an ideology, as an instrument, right? What are you going to have the court do? And then what's the correct location? What's the correct venue? What is it, the institutional kind of guideline you're looking for? And remember, you have to follow the rules of evidence. And then data. What did you decide to use, right? Because every decision you made to look at, like you looked at a film, you looked at an article, you looked at a report, you interviewed some folks. But what else is there, right? What else could you have looked at? And then what did you learn from that data? What is the thing that really stuck in your mind and how do you relate to it? And consider revising your thesis and inquiry. On one of the talks today with students, she said she might want to do that. I think it's a great idea. Like I said in another presentation, we do it all the time. I just did it actually this morning when I was working on a paper. And then we want to think about what did we learn, right? So there's what you learned, but then what did we learn from this process? In other words, each of your contributions is going to teach us something more about how we can actually make social change using human rights law and the United Nations Sustainability Goals. And we want to think specifically is how can we share this with ordinary folk? So I wanted to give you just kind of this to push you along. This is going to be kind of the stuff you work on for your final. Again, upload it onto Google Docs and just keep putting stuff up there and I can help you organize it and help you work through these problems. I know this is much different than doing it in person, and so I want to make sure I'm giving you as much information, as many visuals, and as much feedback as I possibly can so that each person can work towards their grade. A grading rubric will be coming out soon, okay? I will be bringing out a grading rubric soon.